Good morning. I'm Gary DeWaal, and this is Bridging the Week for October 3rd to 7th, and today is October 10th, 2016. The CME Group settled a disciplinary action with a trading firm solely on the basis of its strict liability under applicable exchange rules for the acts of two of its employees. Meanwhile, ICE Futures US proposed amended guidance to authorize the settlement of certain forward contracts and swaps through exchange-related position transactions and revise previously proposed amended guidance related to the pre-hedging of block trades. I didn't expect to be here today. However, because of Hurricane Matthew, a wedding I expected to attend this past weekend in Florida was canceled. So I can make the most of extra unexpected time in New York City. Let's get started. CME Group brought and settled an action against Geneva Trading USA LLC and two of its employees, Christoph Marzek and Robert Kimmins, for engaging in alleged spoofing-type activities on the New York Mercantile Exchange and the Commodity Exchange from March 2013 through July 2013. Geneva Trading is both a COMEX and NYMEX member. According to CME Group, during this time, both Mr. Marzek and Mr. Kimmins on NYMEX and Mr. Marzek alone on COMEX purportedly engaged in a pattern of activity where they entered large-size orders for futures contracts on one side of the market and canceled them, quote-unquote, several seconds after smaller-sized orders on the other side of the market were executed. CME Group claimed that these individuals placed their larger orders to induce other market participants to trade opposite their smaller orders. To resolve his COMEX and NYMEX charges, Mr. Marzek agreed to pay aggregate fines of $90,000 and to serve a 20-business-day all CME Group exchanges access suspension, while to resolve his NYMEX charges, Mr. Creemans agreed to pay a $60,000 fine and serve a 10-business-day all CME Group exchanges access suspension. Both individuals were charged by CME Group with violating just and equitable principles of trade and related provisions. Geneva Trading was also charged with violating just and equitable principles of trades and related violations, but solely on a strict liability basis for the actions of its two traders. To resolve the CME Group disciplinary actions against it, Geneva Trading agreed to disgorge aggregate COMEX and NYMEX trading profits of $91,241. CME Group's strict liability provision may have some profound consequences for firms' automated trading systems gone bad. The article version of Bridging the Week on my website has some thoughts on this. Check it out. ICE Futures US proposed to amend its guidance regarding exchange for related position transactions to make clear that swaps that will settle or forward contracts that may settle through EFRPs will not be considered to be part of prohibited transitory EFRP arrangements where the swap or forward contract is, quote, subject to market risk that is material in the context of the transaction. For example, said IFIS, under its new guidance, parties could agree to enter into an OTC transaction that settled through an exchange for swaps on a specific futures date that reference a specific futures contract settlement price on a specific date or on the average price of a specific futures contract over a defined period. Likewise, a forward contract could be entered into that calls for a delivery, quote, of a carbon emission certificate that may be priced at a premium or discount to a subsequent state or government auction price and may include an option to settle the delivery obligation by executing an exchange for physical after the auction price is determined. Because in both examples, the initial related position transaction was subject to, quote-unquote, material market risk, the agreement to settle the transaction later through an EFRP, quote, would not render the EFRP transitory, end of quote, said IFIS. IFIS submitted its proposed guidance to the Commodity Futures Trading Commission for its approval on October 4th. And finally, ICE Futures US slightly revised a proposed guidance regarding block trades that had previously submitted to the Commodity Futures Trading Commission in June 2016 that will permit certain pre- or anticipatory hedging by a counterparty prior to a block transaction being formally executed. Under IFIS's proposed guidance, the principal party to a proposed block trade may engage in pre- or anticipatory hedging of the position they believe in, quote-unquote, good faith will result from the, quote-unquote, consummation of a block trade. However, this ability would not exist for, quote, an intermediary that takes the opposite side of its own customer order, end of quote. As proposed, an intermediary will be permitted to enter into transactions to offset the position that will result from the block trade only after the block trade has been finalized. IFIS's proposed amendments to initial CFTC submission see mostly non-substantive wordsmithing, but the exchange expressly clarified that its proposed guidance would not affect any requirement under applicable law or regulation of the Commodity Futures Trading Commission. IFA submitted its proposed revised guidance to the CFTC for its approval on October 4th. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.